Hey, everybody, and welcome to the latest edition of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners redomesticate out of high tax, business unfriendly environments to greener pastures. Today, I am examining a report from Community Impact Magazine authored by Hannah Norton, dated March 4th, entitled Over 300 Companies Move Headquarters to Texas in 9 Years. But before we get into that, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the multi state, multi attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, as well as a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications covering accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. And just in case you are wondering if I look a little bit sunburned, well, it's because I am. But with that out of the way, this report explains, as you might surmise from the title, that over 300 large companies have moved their headquarters to the Lone Star State in less than the last decade. That number comes straight from the Texas governor's office, and it is not showing any signs of abating. In 2024 alone, at least 24 major companies relocated to Texas, with more than half of them relocating to the Dallas-Fort Worth Metroplex. Chevron left California for Houston, Caterpillar left Illinois for Irving, Tesla left California for Austin. These are not small businesses. These are Fortune 500 enterprises with armies of lawyers and accountants, and they all reached the same conclusion. Texas is where it's at. So, why Texas? First, no state level personal income tax. That's the big one. No state level income tax or franchise tax for most company types, including most small businesses, LLCs, sub S, and partnership entities. A constitutional amendment passed by Texas voters in November raised the personal property tax exemption for businesses from $2,500 to $125,000, meaning equipment, furniture, and vehicles are now sheltered from taxation up to that threshold as well. The state has invested nearly $500 million in semiconductor projects under the Texas Semiconductor Innovation Fund. Manufacturing and research companies can apply for up to a 75% reduction in the taxes they pay to local school districts under the Jobs, Energy, Technology, and Innovation Program. Texas received Site Selection Magazine's Governor's Cup for the 14th consecutive year in a row. That award goes to the state that attracts the most job creating projects. That's 14 years consecutively, and no other state has yet come close. Governor Greg Abbott put it plainly: Texas is the most business friendly climate of any state in the nation. Now, here's the question that matters to you as a business owner. You have an existing company, or at least I assume you do, or you wouldn't be watching this video. And perhaps you wish to move it to a new state, perhaps even Texas. So, what do? Most people will get this wrong. In fact, most attorneys will get this wrong, and the internet, Reddit, and AI will absolutely get this wrong. There are 4 paths in front of you. Choose wisely. Option number 1, redomestication. Option number 2, foreign entity registration, also sometimes referred to as foreign qualification. Number 3, merger. And number 4, dissolution. Now, only one of these works consistently for most business owners who wish to permanently relocate their company to Texas. Let me briefly walk you through each one. And by the way, I've made tons of videos on each of these, so feel free to review my channel if you'd like to dive a little bit deeper. I'll keep this fairly high level, and I will not waste your time giving you the wrong information. Let's start in reverse order if we can. Dissolution means killing your company. It is the equivalent legally of the death penalty for your business. You dissolve your company, you lose your existing contracts, your credit history, your bank accounts, your tax elections, your federal employer identification number. All of that goes right out the window. You start over. You also potentially trigger a taxable event at the federal level and perhaps even at the state level in your prior jurisdiction. Dissolution, as I said, is the death penalty for your business. It is only appropriate if you are going out of business. Now, if someone is suggesting dissolution, or they're throwing that word around as a means of relocating a business, run, do not walk, run out the door and find a different attorney, because in all likelihood, they don't know what they are talking about. Merger, on the other hand, means usually forming a new company and merging your old company into it. Now, in the old days, merger was the most common mechanism to relocate an existing business enterprise to a new jurisdiction. But as I said, that's the old way of doing things. Redomestication, as we will come to in a few minutes, is the newer and in many cases better option. Legal fees for a traditional merger routinely exceed $10,000, $20K or more, and the surviving entity may receive a new federal employer identification number, which creates tax headaches. Not to mention the fact you will likely need to novate or renegotiate your existing contracts, meaning you go back to every vendor, every customer, every bank, and start from scratch. New bank accounts, new registrations. Federal tax complexity under the Internal Revenue Code is substantially higher in a merger context, and they are easy to make mistakes with. Very expensive mistakes, I might add. One missed consent, one broken assignment clause, one licensing mismatch, and what seemed to be a simple, and I use that word in air quotes, simple administrative exercise becomes a business interruption. Mergers, at least in this context, are a relic of the old days of corporate law before redomestication became available. Do not use a hammer, or more accurately, a chainsaw, when you have access to a scalpel. Foreign entity registration, sometimes referred to as foreign qualification, is another option that some attorneys commonly recommend. And while it makes sense in some cases, it is simply wrong for most business owners who have permanently ceased operations in their prior state and have relocated down to Texas. Here is why. Foreign registration permits your company to do a business in Texas. But, and here's the important part, your company remains domiciled in your prior state. In other words, you did not move the company at all. Now, under this regime, you must maintain compliance, pay fees, file reports, and potentially pay taxes in two states. You continue paying those taxes so long as your company remains domiciled in that prior state. You have ongoing registration obligations there as well. You have not, as I said, changed your domicile at all. You have simply added Texas as another state of operation. Business owners who mistakenly take this path often discover the error only after paying years of unnecessary fees and taxes in their old jurisdiction. It is the most expensive, cheap option available. Now, I saved the best for last. Redomestication is usually the correct answer for many business owners who are permanently relocating from one jurisdiction to a new jurisdiction. The technical term for this process varies widely depending upon the states, but sometimes you will hear it referred to as conversion, continuation, statutory conversion, domiciling, domestication, redomestication. The list goes on. What it means in plain English is this: your company changes its legal home state from your prior state to your new state, which in our example is Texas. Here's the key point: no new company is formed. Let me say that again. It is not a new company, it is a continuation of the existing company. Your existing federal employer identification number carries forward. Your existing contracts remain in full force and effect because the company that exists after the redomestication is completed is the same legal entity that existed before. Your bank accounts follow you. Your credit history follows you. Your business name, in most cases, follows you as well. The company's tax attributes at the federal level, including basis and assets, carry forward without adjustment or revaluation under sections 351, 355, and or 368A of the Federal Internal Revenue Code. This is a non-taxable kind of reorganization when executed correctly, and that is what you want. Again, when performed correctly, you write no check to the IRS and no check to your prior state as a result of the move itself, although every situation is different. Now, the catch here is when executed correctly. That's the key phrase. This is not a do-it-yourself project. Far too often, I get people emailing, calling, and they say, "Hey, Chad, I'm trying to save a few bucks here. I filed some papers to try to make this easier for you. Can you give me a discount?" And I say, "Well, not only can I not give you a discount, but I got some bad news for you. You dissolved your company, and you may be looking at a 6 or 7 figure tax bill payable to the IRS." Now, those are exactly the kind of situations we try to avoid. Look, I don't know anything about woodworking. If somebody was to ask me a question about woodworking, I would say, "Hey, I'm not an expert on that." Right? So hopefully you can appreciate the intricacies and the nuance that go into this complex intersection of state and federal law. And let me be a little bit more concrete about that. Texas law requires, among other things, a certificate of formation, a certificate of conversion, a plan of conversion. You're not going to find that online. Good luck if you use Grok or Claude, although Claude's getting better, but still has a ways to go. As well as a unanimous written consent or board meeting minutes formally adopting and ratifying that plan. Now, you might find templates for a certificate of formation on the Texas Secretary of State website. Fine. Good luck finding the plan of conversion, as I said, which, by the way, is the most important legal document in the whole stack, so to speak. It controls the entire transaction. And this is a custom legal instrument that must be prepared by a licensed attorney. Trying to write one yourself is like performing brain surgery on yourself without anesthesia and without the benefit of having gone to med school. Good luck. Even if it's possible, you probably will not like the results. This plan of conversion, which, as I said, is the most important document, is not a suggestion. It's not nice to have. It's not optional. It's not a mere formality. It is required. Both your prior state as well as the state of Texas require its adoption as a legal prerequisite to the filing, and omitting it can result not just in rejection of your filing or a defective conversion that has no legal effect, but could result in what we call a busted transaction, as well as loss of the non-taxable character of the transaction under federal law. Filing a certificate of conversion without first adopting a proper plan of conversion is not just a mistake, Under the Texas Business Organizations Code, filing an instrument you know to be materially false with the intent to harm or defraud is a state jail felony. I'm not trying to scare you, but you need to do your homework. The good news is that when this process is performed by an experienced attorney, it can be accomplished in as little as 2 or 3 months. And in some cases, we can get that down to about a week and a half, although that is an unusual case where there's a lot of expediting involved, but it's certainly possible. And this costs a fraction of what a merger would normally cost. And let me emphasize this, there's no downtime when it's performed by somebody that knows what they're doing. There's no renegotiating of contracts. There's no need to create new bank accounts unless you want to. We usually are able to perform redomestications at a flat fee, as you will see on my website. And look, if you're thinking about moving your company to Texas, you are in good company. As I said at the beginning of this video, over 300 large companies and countless small and medium-sized enterprises have already made the move. I have dozens in process right now from all over the country. The trend is not reversing. Texas is not getting less business friendly, is getting more business friendly. If your company has permanently relocated to Texas or you are in the process of doing so, the question is not whether to formalize that move. The question is, how long are you willing to operate in legal and tax limbo whilst your competitors are operating legally from a state that actually wants them there? If you have questions regarding redomesticating your existing LLC or corporation, please use the link in the description for more information on this process and to schedule time for us to speak about your specific scenario. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier presentations, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for that consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.